Please.
Thank you, Judge. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-7018. Inna Khodorkovskaya, appellant, versus Jacquelyn G. Gay and Kenneth K. Lynn. Mr. Foster for the appellant, Ms. Wall for the appellee.
Good morning, counsel. Mr. Foster, when you're ready, please proceed.
Thank you, Your Honor. Good morning, and may it please the court. The court below erred in concluding that no reasonable person could believe that Inna Khodorkovskaya had been really called a prostitute and a murderer, and even if that were not the case, that those were simply unverifiable facts. To the contrary, the entire play focuses on the poem that's set forth in the prologue and its theme, the downfall of a powerful man because of his captivation by a voluptuous prostitute who orchestrates a murder for which he is blamed.
Mr. Foster, can I ask, how do we know that the whole play focuses on that poem? I've watched the play, and to be honest, I'm not sure what it focuses on. I think that's open to interpretation.
I believe when you repeat something 3 or 4 times during a play, it's pretty focused.
I mean, Mr. Foster, the tiger appears 2 or 3 or 4 times. It's not a play about a tiger.
No, I agree. It's not. In fact, the tiger is nothing other than another literary method of showing the Putin character's strength and power.
That's just kind of, I think the point of your opposing counsel is a lot of the play is, whether we call it literary method, literary license, artistic license, dramatic license, poetic license, historic license. This is a concept that's so familiar in art that we have half a dozen or a dozen words for it. How do we know that the portrayal of your client as a prostitute and a murderer is not historic license?
Because the play has a theme, and there's no question about what the theme is. The theme is the downfall of a powerful man because of his fascination with the prostitute who orchestrates the murder which causes his downfall.
Assume, Mr. Foster, that I think that we can't know with certainty what the theme of the play is, that's a question of that 100 people might give 100 different answers to. Assume I think that. I know you don't think that. Tell me how you can still win.
Because that's the issue for the jury. The issue for the court is, can it be interpreted this way? The issue for the jury is, does a reasonable audience interpret it that way? And so
when we look to a reasonable audience, I worry that your argument would require us not to ask what a reasonable audience member would think, but rather what the most gullible possible audience member would think. Because I will admit, I think there is probably an audience member in the crowd that will watch that play and will think gullibly that everything he is watching is an assertion of historical fact, the same as if he were reading an affidavit. But I'm not sure how a reasonable audience member could possibly think that when, for one thing, there's not only a tiger, but there's a ghost. There's Vladimir Putin quoting poetry. And it just seems like there's a lot in this play that a reasonable audience member would say, as I say when I'm watching a movie like Braveheart or a TV show like The Crown. I wonder what's true. I'm not sure. Maybe I'll look it up on the internet, or maybe I won't, and it's more fun to just not know. Isn't that what a reasonable audience member would tell me? Why a reasonable audience member would not think that?
Not sure that's the standard. I think what Moldea tells us about Milkovich is that when somebody does a play of this sort, an author and a playwright, that they have to be sure that they don't, as Bugliosi says, they have to be sure that they avoid the impression that they are asserting objective facts. And when you,
Mr. Foster, tell me, and then I'll get out of the way here. Tell me how I can distinguish this play from a TV show I just mentioned that, frankly, I've been watching all week, is Netflix's The Crown. And some of it's true and some of it's false. And the writer of it says, I made some of it up. And if you go on the internet and Google how much of The Crown is true, you get 65 million results with article after article listing all the things that are true, all the things that aren't. And in fact, one of the most renowned historians of the monarchy has written an entire book about what in The Crown is true and what in The Crown is false. And he goes episode by episode. How is this play different than that TV show? Or is your argument that the Queen of England has a false light claim against the Netflix show The Crown?
if the Crown had implied forcefully that the Queen of England was a prostitute and a murderer, she would have had a false light claim. What this boils down to is you can't, as it says in Moldea, you can't just cloak a garden variety libel in a literary form and get away with it.
So can I ask the following question? I think what you said earlier, at least in my mind, is one of the key questions in the case, which is what goes to the jury and what is something that a court decides and doesn't let it go to the jury. And you don't take the position that there can never be a work of historical fiction that's a play, such that there's certain things in the play that take license with respect to history, and a court could decide as a matter of law that that's just not something is going to go to a jury. Right? I mean, there's got to be some situations in which a court can decide that as a matter of law.
Absolutely. The court can decide it. And the
I'm sorry, can you just make sure you're speaking into your microphone? I'm having a little trouble hearing you, sorry.
I'm sorry, sir. Yes, sir. I don't take that position, but the closer you get in your literary work to calling somebody a serious criminal, the less leeway you have.
Why is that? Because that seems to me, you can take literary license or dramatic license with that kind of assertion, no less than with any other kind of assertion. So is your position that it's the nature of the assertion that determines whether it's something that goes to the jury?
It's not only my position. I think that's the position of this circuit in Moldea. That's what the court says in Moldea. In fact, in Moldea it says, talking about Milkovich, it says Milkovich did not disavow the importance of context, but discounted it in the circumstances of that case. This would not be the case, talking about Moldea, if the review had said it was a badly written book because its author was a drug dealer. In that case, it would parallel Milkovich. The reviewer would have been employing the medium of a book review for what was a garden variety libel.
I think there's several different issues in a case like this. One of them is whether something's capably defamatory. And of course, it's true that when you accuse somebody of being a criminal, there's more of a sense that it's defamatory than some other things you could say about them. I get that. But is it your view that you can never have a play that's a work of historical fiction that suggests that a character is a criminal and have that be something that's interpreted as a matter of drama? Or every time you make a suggestion in a play that someone is a criminal, that's necessarily something that goes to the jury?
No, not at all. In fact, that's what I think Levin teaches us, that if you're making that suggestion and you lay it out with 3 or 4 possible scenarios or 2 possible scenarios with facts supporting each one and give the audience the choice between those scenarios, you can do that. But
is that right then? So the playwright is limited to putting on a play. I mean, first of all, it's going to make a lot of plays 4 times as long if you have to set out 4 scenarios, right? And so one question is that what a playwright has to do? Or can they give one scenario that itself is something that's a matter of conjecture? No, it's not that. I suspect that it's not that you have to give alternative scenarios to the audience. You can just choose one scenario and still describe it in such a way that it's still understood by the audience, or should be deemed to be understood by the audience as something that's a dramatic suggestion because it's entertaining, as opposed to an assertion of fact.
And if you are careful and tell the audience that, And most important, if your play can have meaning without it saying that the person is a criminal. Here, this play has no meaning in the absence of the fact that Anna is a prostitute and a murderer, because that is the theme of the play. The downfall is caused by his fascination with this woman, and that she is this person. If they had wanted to say that Khodorkovsky had his downfall because he created the murder, that would have been a theme for the play. But that's not what they said.
But I guess to me, it seems like we're conflating two things, because for these purposes, for purposes of this appeal, the district court assumed that the play asserted that she was a prostitute and a murderer. And then I'm willing to assume what you're saying, which is that this is a theme of the play. That's for purposes of the exchange we're having right now. The question in my mind is, even if we assume that that's the theme of the play, is an audience member supposed to be deemed to assume that the play actually is accurately recounting what in fact happened as a matter of historical fact? Or is an audience member thinking, well, yeah, this is loosely based on a historical episode, but it's just drama. And so I don't actually know what particular part of this is true and not true. It's just giving me something that's supposed to entertain the audience. It in fact has segments of the play where the characters are directly speaking to the audience. Nobody thinks that actually happened as a matter of history. And so the whole thing is couched in this notion that, yeah, we're taking some dramatic license here. We're grounding it in historical fact. And none of this should be taken as the gospel truth about what in fact happened. It's a drama about things that may or may not have happened.
I don't think that's what the play does. The play is devoid of meaning if that's what it's doing. The only way it has meaning is to assert that she is a prostitute and a murderer, and that caused his downfall. Otherwise, the play has no meaning at all.
Okay, let me make sure my colleagues don't have additional questions. If they do, please.
None for me.
Oh, I think you're muted, Judge Walker.
Thanks. Sorry about that. One question, Mr. Foster. Can you give me the best case that you think I should go read that involves a play or a television show or a movie? And, you know, for your sake, this case would presumably rule in favor of a plaintiff in a false light claim or a defamation claim or something like that. But it needs to not be a newspaper article or a book review or an op-ed or a book. It needs to be a work of art on stage or on the screen. Can you give me a case I should go read?
The only one that I can come up with real quickly that was a work of art, as you put it, that you watch as opposed to one that you read. I don't think there is a distinction, but assuming that there is a distinction, that's de Havilland, which is the work of art. But and de Havilland itself shows us that there the court concluded that it was complementary to de Havilland, but that is one where there's a work of art, as you described it.
Was Partington did Partington not involve a TV show?
Partington was that's Bugliosi. Yes, it did involve a TV show, and I'm glad you said that, Judge, because that Partington is the case which specifically warns producers and authors of docudramas. It uses the word, and that's what the judge below seemed to like to call this, to avoid creating the impression that they are stating accurate facts, historical facts.
Well, I just wanted to make sure I'm just trying to recollect what the facts involved. Did it in fact involve a show, or did it involve an article, or both? I can't remember.
I believe it involved
a book.
Show.
A book and a show, maybe? Okay.
Yes, I believe it was a show based upon a book.
Who won in Partington? The plaintiff or the defendant?
The defendant won in Partington.
Your best cases on your side are cases where the plaintiffs lost.
Well, I think if the case is set forth the circumstances in which the plaintiff wins, then yes. But I think our best case is Bugliosi in this circuit. And I think it sets out the law absolutely. Thank you, sir.
Thank you.
I
Thank
do
you.
have
Please.
a question, Mr. Foster. Number one, let's see. You seem to say that this play has to have meaning. Do you have any authority for that proposition? Frankly, although I didn't watch it, did get a scene-by-scene description of it, and it had very little meaning to me, if any. And the other question is, can we not use the playbill, which gives at least constructive notice that this is a fictional play?
To answer your last question first, I don't think you can, but even if you do, the nomenclature that you place upon it is not going to save it. Because if a work that purports to be a work of fiction, just saying that it is a work of fiction doesn't save it, just like just saying it's a docudrama doesn't save it. If it infers that the person is a prostitute and a murderer, and the entire thrust of the play cannot have any meaning, to whatever extent it does have meaning, if it will have zero meaning at the end, if it has no artistic value whatsoever, then it becomes pornography, as it were. And the question is, does the nonsense that introduces pornography save it? Well, does the nonsense save this thing in which Ms. Khodorkovskaya is called a prostitute and a murderer? And I don't think you can just put a title on it and save something.
Okay, thank you.
Yes, ma'am.
Thank you, Mr. Foster. We'll give you some time for rebuttal. Ms. Wall.
Thank you, sir.
Thank you, Your Honor. Barbara Wall on behalf of the appellees. May it please the court. The district court correctly ruled that the First Amendment protects the artistic expression that is the play at issue and requires dismissal of both the false light and the intentional infliction of emotional distress claims. It is abundantly clear that this is not a factual endeavor. This is a play. It is pure fiction, in the words of Partington.
Why would you say it's pure fiction? It seems to me that that seems to be taking it a bit far. I mean, it's at least historical fiction, right? It's grounded in actual historical events. There's no doubt that the mayor, in fact, was murdered.
The mayor was murdered,
right.
And there are characters who have names similar to those in real life.
Well, are they similar? I thought they were the actual names.
Some are real names.
Well, how about the plaintiff?
That is, the Ina character has that similarity.
How about Vladimir Putin?
He shares the same name.
How about her husband?
He shares the same name.
Right. So the relevant people, it seems like, and the mayor.
The mayor, as well as the Mikhail character's two business colleagues. And there is a Yuko soil. That's all correct.
I understand. I get that you're saying shares the same name. I don't know exactly what the layer of remove is between is the same name or shares the same name, because it seems to me the play is describing the actual people in the world. That doesn't necessarily mean that you lose, but it seems to me to say that it's purely fiction elides what can make this kind of case difficult, which is that at least in some situations, I would assume that a production that recounts historical fact and purports to accurately recount historical fact can be the subject of a defamation or tort action of the kind that's at issue here, on the basis that even though it's purporting to recount to every jot and tittle historical fact, it's actually getting grievously wrong, injuriously wrong, some part of it. Or do you think that can never happen?
Well, I don't want to say never, but as the tagline of the play says, it's a fictional play inspired by historic events. So there are some similarities, but there are also vast, vast dissimilarities. If you looked at the general arc of the story, there is a man named Mikhail Khodorkovskaya, and he got into a big dispute with Putin, He was a political prisoner for years, and then he was released. That's what the complaint says. And he has a wife in real life whose name is Inna Khodorkovskaya. I would submit that while there are similarities to that in the play, the aspects of the play that the plaintiff finds grievous are constructs.
So then the question in my mind is, in which situations does a question like that go to the jury? And in which situations does a court decide it as a matter of law, even on a motion to dismiss? And let me ask you about Hustler v. Falwell, because you cite it in your briefs. And in Hustler v. Falwell, the same issue that to me lies at the center of this case, which is whether the portrayal of the individual, in this case as a prostitute and a murderer, I know you think it doesn't portray her as a prostitute and a murderer, but let's assume that it does because the district court did, and that's the posture in which we face the case now. The question is whether that portrayal is describing something that's an actual fact, or is it something that should be deemed by the viewer to be within the canon of dramatic license. And in Falwell, that question went to the jury. And what you're saying is here, that question should be decided as a matter of law. And I'm not suggesting that you're necessarily right or wrong. I'm just wondering why it is that in a case like Falwell, that question went to the jury. And in a case like this, it would not go to the jury.
The court has the gatekeeping function. If the cause of action fails to stand as a matter of law, as this one does not, the court has the obligation to dismiss it. And I think a closer case than Falwell is the Farah case out of this circuit, in which the court said, and that was the case, because I know there are a lot of these, that was the case where there was a satirical statement posted in which an opponent of a book writer about Obama birther allegations put up a statement on a blog post saying that the publisher was going to stop publishing and pulp all of these books related to claims about then President Obama. The court and real people were confused. There were people who responded by saying, do I get my money back about this book? What's happening here? And the court explained at great length about how satire works, and real people's names don't make the First Amendment protections go away.
So I don't disagree with you on that. I think you could have, certainly you can have a work of art that uses real people's names and is grounded in historical events, but takes dramatic license and ought to be understood by the audience as being a work of dramatic license such that they can't take literally everything that's said. I think that just seems like that has to be true. My question is, how do we draw the distinction between those situations in which that issue, whether the work is asserting the disputed the disputed fact as an assertion of historical fact, or whether it's something as to which the audience ought to understand that it's a matter of dramatic license? How do we determine those cases in which the court decides that as a matter of law and those cases in which it's sent to the jury?
I guess two responses to that, Your Honor. First is context. And that's baseline black letter defamation jurisprudence. And on the one hand, you have matters that, like the Farah case, where is this real or is this not real? And the court put itself in the position of the reasonable blog viewer. And in this instance, it would be the reasonable theater goer. That's at one end. All the way at the other extreme is you have this case, which is based on the context. It has to be fiction. It says right in the tagline, it's fiction. You don't go to Arena Stage to get a documentary. You go there to be entertained with the theatrical production. If you look at the abundant number of elements that clearly are stagecraft, that are inspired art, it's not just the tiger and the dead ghost mayor. It's the lawyer in the cell who's talking to the Mikhail character, and then he's suddenly speaking to a crowd, and there are voices chanting the protagonist's name. And I say protagonist because that this is a play about, as the complaint says, about the Mikhail character and his fight with Putin.
And would you not say that? So I think a lot of that is well taken. Would you not say that about the parody ad in Hustler versus Falwell? It seems like a lot of the context, I mean, the magazine it was in, the type of stuff that would typically attend that placement, seems to me to be something that you would take account of as a matter of context, and a court could just say as a matter of law, we're not going to let the jury decide whether, as the court says at page 57 of its opinion, whether the Hustler ad parody could be reasonably understood as describing actual facts about Falwell or actual events in which he participated. But that issue still went to the jury in that case. And maybe it was wrong to go to the jury. The Supreme Court didn't necessarily say it was right or wrong, but that's in fact what happened in that case.
Correct. And it should not hear. In the words of this court in Farah, having a matter go that should be dismissed is not only useful or a misuse of resources, but it subjects the parties in the court to needless litigation. That's the purpose of a motion to dismiss. And that is what should be done here. You can't, in the words of Iqbal and Twombly, you can't cure a deficient complaint that fails to state a cause of action as a matter of law by giving the party some additional discovery. And as the district court asked Mr. Foster repeatedly, well, what kind of discovery would you have here that would make any difference? And there isn't any. There isn't any.
Can I ask you just the same question that Judge Henderson asked, which is that you referred to it a couple of times, the tagline.
Yes.
So as I understood it, the district court decided not to take that into account, but granted dismissal anyway. And it may be that, you could say that, look, when you watch the play, you don't need the tagline. You understand that from watching the play, but the tagline is helpful to you. That's why you relied on your briefs, and that's why you invoked an oral argument. What's your view on whether we can take account of that at the dismissal stage?
You can, because it is, the court should be viewing the alleged defamatory work in context. And context is not just you can't just cherry pick certain lines out of the play, but you experience the play as the play. And
but the tagline isn't in the play.
It is in the playbill, which if you looked at the video, you see audience goers leafing through the playbill. It is also,
I didn't have binoculars to see what the audience members were leafing their way through. So I'm actually asking a serious question, I think, which is that I understand that the play and the video should be treated by us as an evidence because both parties seem to agree on that. But I don't know that means that every single thing that is associated with the play. And again, I'm not saying that you necessarily need it, but it is something that you rely on quite a bit to some effect. And I'm wondering whether there's law that says that a separate document, that's in a website description is something that we take account of at the dismissal stage.
I believe there is case law on that. And I'm thinking of the several cases that, for example, Deripaska, which was affirmed by this court, where there was recognition of historical articles related to the defamation and to the claims of the plaintiff. But as the district court said, you don't have to go there. I mean, if it's helpful, it sets the stage, no pun intended, when you walk in and you have in your hand, as well as you have purchased tickets that through the website, which is used a lot. I'm not going to go beyond the four corners of this, but there are purchases done on the website. And the play's title is Kleptocracy, a fictional play inspired by historical, inspired by historic events.
Well, is that's in the title? What you just said?
That is the tagline to the title. Yes. Which is why we cited showed the website Of course, if you are a theater goer and you walk, there's no scrim, there was no stage, you come and you sit down and there's a bare stage. There's nothing that shoots the name of the play and the tagline on the screen as you're standing there.
But with
You keep saying tagline. Sorry, you keep saying tagline. What do you mean by tagline? Is that the same as subtitle?
That's a good way to phrase it. Yes, the name of the play is Kleptocracy, and then there's this sentence that goes underneath it. Subtitle, tagline.
Do we know whether the people who actually viewed it, you couldn't view it on a website, could you? Don't you have to go to the theater?
You do.
All right. And aren't they handed playbills?
They are.
So they have constructive notice that it is a fictional play.
They do, Your Honor.
All right.
We would agree with that position.
Is the subtitle on the program?
It is. It's also, again, on the website. But the district court, found that the tigers, the ghost, all of these other elements injected that without having to be told this is a work of fiction. But either way, we believe that the district court got it right and dismissal was appropriate of both claims.
Make sure my colleagues don't have additional questions for you, Ms. Wall.
I'm just not. I'm looking at the Arena Stage website and the title of the play. It looks like the full title, including any subtitle, is Kleptocracy, period, full stop. But you're telling me that, like, this play, the full title of this play, including its subtitle, is Kleptocracy, a work of fiction, et cetera, et cetera?
I can't get on the website right now, Your Honor, because I'll disconnect from
Well,
you.
no, I mean, I'm not asking you to confirm or deny the website. I'm just trying to get clarification on what you are asserting here today.
So when the tickets were purchased, and our brief at Joint Appendix page, I think it's 24, cited the place where you could buy tickets. And the play was then referred to as Kleptocracy, a work of historic play inspired by historic events. I can't say whether that has changed since you can no longer buy tickets. It was available only through January 2020. So what you might be seeing on the website now, Your Honor, is may not be what a theater goer saw when he or she purchased tickets.
But you're saying that every theater attendee got a program that included the words on the cover, after Kleptocracy, fictional play inspired by historical events.
That's correct.
It's on the cover of the program.
Yes, it is. I would try to get you some binoculars, Your Honor, but perhaps we should have done that before.
I'm not sure that they have a PDF of the program, and it doesn't say what you're saying it says. I don't think it matters, but.
Okay,
yeah, I'm not necessarily saying that it matters, but I'm curious about it as a matter of historical facts, so to speak. But okay. All right. Thank you, Ms. Wall. Unless my colleagues have anything further, Mr. Foster will give you 2 minutes for rebuttal.
Thank you, Your Honor. You asked which are the ones that go to the jury and which are the ones that don't go to the jury. The ones that tell you that they are presenting facts and that they're presenting hard math, those are the ones that go to the jury. The ones that say, well, we don't know, this may be the case, this may not be the case, but remember, immediately after the murder scene, Putin comes back and he says, I'm going to tell you, I forget his exact words, but you can't incontestable, that's what he says. I'm going to tell you incontestable facts about Khodorkovskaya. He says, for those of us in the audience who like our incontestable facts. And then he says, and insofar as the murder is concerned, we think it is hard math for those of us in the audience who like our hard math. The play is telling the audience, for you, we are presenting incontrovertible facts and hard math. Those are the ones that go to the jury. Now, also in Farah, which was mentioned, Farah didn't accuse anyone of criminal conduct. That's the distinction that Moldea makes. When you accuse someone of criminal conduct, it becomes a garden variety libel, in which context, as Moldea says about the case involving the sports opinion, Moldea says it didn't have to go there because it was a garden variety libel accusing of criminal conduct. That's what sets this case apart, and that's what makes it go to the jury. I might, just as an aside, arena stage is not a place where gullible people go. It is a place where sophisticated people go. And they go because they want to see the connection of true figures to what the playwright is asserting to be the facts, the irretrievable, immutable facts and hard math about those players. Thank you, sir.
Okay, counsel, thank you. Unless my colleagues have questions for you.
I just wanted to make one clarification, especially to be fair to Ms. Wall. There, on page 1 of the program, it only says kleptocracy, but on page 11, there's something called title page, and it does say kleptocracy, a fictional play, as Ms. Wall described. So I don't even know if this is something we can take judicial notice of. I don't think it matters to the reasoning, but I did want to be fair to both Mr. Foster and Ms. Wall.
Thank you very much, Your Honor. It made me nervous, but thank you for correcting that.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Thank you.
Thank you.
Case number 19-1068 et al., BCP Trading and Investments LLC et al. Versus Commissioner of Internal Revenue, Virginia Simpson, appellant. Mr. Marwell for the appellants Calcoven Petit Partnerships, Mr. Clark for the appellants Esri LeMay Partnerships, Ms. Rubin for the appellee Commissioner of Internal Revenue.
Good morning, counsel. Mr. Marwell, when you're ready, please proceed.
Thank you, Your Honor. May it please the court, Jeremy Marwell for the Calcoven Petit appellants. I will address the statute of limitations and sham partnership issues, questions about Calcoven and Petit. Mr. Clark will address the Rule 63 issue, questions about Esri and LeMay. And if I'd like to reserve 2 minutes if I can. The statute extensions in this case were invalid because they were signed at Ernst & Young's urging and direction at a time when the government at least had reason to know of Ernst & Young's serious and undisclosed conflicts of interest. And that is so for 2 main reasons. First, the tax court was wrong to conclude that just because taxpayers had notice that the IRS was questioning the transactions, they also had noticed that Ernst & Young, their trusted advisor, was itself under criminal investigation and faced intense pressure to put its own interest above its clients. Ernst & Young's disclosure letters were at best half-truths and never timely disclosed the existence of a criminal investigation. Second, the result here, in our view, is a straightforward application of Transpac and black letter contract and agency principles. Ernst & Young ran the show with these transactions. The record shows that Bolton and the taxpayers relied entirely on Ernst & Young's advice to extend the limitations period, and the IRS knew, or at least had reason to know. The IRS knew about the existence of Ernst & Young's conflicts because it was involved in creating those conflicts, and it knew that Ernst & Young was not disclosing those conflicts to its clients, among other things, because Ernst & Young told the IRS that and said, we cannot disclose that we're paying a penalty here, otherwise our clients will use it against us in litigation.
Can I ask you a question, Mr. Marwell? So one part about your submission that I don't completely follow is the reason that the IRS would let me rephrase it. The reason that it would be disadvantageous to people in in the taxpayer's position to not know this fact, because it seems to me that even if you know the fact, I'm not understanding what's gained by denying the extension. And I know that I know that you rely on Olson's testimony, and Olson says that, well, in some situations, if the IRS has a criminal prosecution in mind, they might forego a civil proceeding. But it just seems to me that that was a conclusion, and I wasn't quite understanding the logic behind it. Why is it that it would be advantageous to deny the extension?
So I think the best part of Olson's testimony is 1901 to 1903 of the JA, where he explains this. And he gives a couple of specific reasons. This is the former Assistant Attorney General for the Tax Division of the Department of Justice explaining how these criminal investigations work. And I take there to be several propositions there. One is that the practical effect of denying an extension could be to accelerate the government's work. The government would have to choose between issuing the FPAW, the Final Partnership Administrative Adjustment, or potentially letting the statute lapse. And if that occurs early in the overall swirl of investigations, as the tax court put it, the government might be effectively locked into a particular theory because it's going to have to issue the FPAW. And Olson testified that it's possible that theory would be advantageous to the taxpayer. It's possible that the FPAW would not include findings that would be necessary to support a later claim of fraud. And there's also the possibility that, there's a desire to keep the criminal investigation confidential, and that might be known enough, or some of the concerns that have occurred in where you have the target of a civil investigation providing documents or perhaps providing information to the government without knowing that there's a criminal investigation. So pending, you might have Fifth Amendment concerns. So there's the need for very careful coordination within the government, and that, I think, is the key problem. That is what the taxpayers here didn't know about. And they
so on that issue, within the government, you mean between the criminal and civil parts of IRS?
Yes, and I think there's also coordination. I mean, here we had the criminal side, I think, kicked off when the Southern District of New York called Ernst & Young's general counsel and said, hey, we saw this newspaper article, please preserve documents, we're considering convening a grand jury. And we have evidence in the record that there was coordination happening both between the civil promoter audit team and the criminal investigative division within the IRS. And you had both Ernst & Young and as I understand, the IRS aware of the existence of the Southern Districts.
What do we do, as between civil and criminal, what do we do with the stipulation that civil didn't know?
So the stipulation, as I read it, talks about the team that was doing the audits, the CDS audits, like of the partnership here. I think the facts are different as to the promoter audit team. So the team within IRS, the civil promoter audit team that was investigating Ernst & Young. And that team, the record shows, had full awareness of the criminal side. In fact, they met with the criminal investigative division in 2003. And you have the Phillips case from the Ninth Circuit, which says, we're not going to look just at what individual employees within an agency, we're going to attribute that knowledge to the commissioner as a whole. So I think unless you want to take a different approach than the Ninth did on that, it's a little slices it too fine to kind of divide division by division. And I mean, the degree of knowledge is something that the tax court did not really provide findings on. As I read the opinion, they more or less agreed with us that Ernst & Young had a conflict, and they agreed that didn't dispute that the IRS had awareness of the conflict. The tax court's ground of decision was focused on the notion that the taxpayers here either should have known or had reason to know. And so if you are concerned about issues like the IRS knowledge, I think that wouldn't be a terrible reason to remand and allow the tax court to make some findings in the first instance, and that you could then potentially review later. But as to the knowledge of the taxpayers, this is somewhere where tax court just had significant errors that I think, even understanding the difficult burden of a clear error standard review, there are problems here. So for instance, the tax court said that in July 2004, Ernst & Young wrote to my clients, the Calcove and Pettit, to disclose the existence of the grand jury investigation. That's just contrary to the stipulation. The stipulation is there is no evidence in the record that those letters were ever sent to our clients. And so when you look at the only other evidence in the record, the earlier disclosures, they're really cramped. And if you look at this through the lens of a fiduciary, it's hard to understand what Ernst & Young was doing. This sort of half-truths. Well, there was a promoter audit, but they don't mention the fact that they paid a penalty. When in 2004, when Pettit called Ernst & Young and said, "What is this about the grand jury?" The testimony undisputed at JA 1419 was that Ernst & Young's contact partner said, "Oh, don't worry about that. That has something to do with some individual partners. It's really doesn't have anything to do with you." And so if you we view TransPac as kind of an application of the more generally applicable agency and fiduciary principles, and it's in our view artificial to distinguish between Bolton, who signed the partnership extension here, and Ernst & Young on these particular facts. I mean, the government raises concerns of what is the practical consequence of our position for their conduct of investigations. And I think the answer is on these facts, where you have Ernst & Young at the center of the storm, and the government went after them first for creating and marketing these transactions. And you had Ernst & Young listed as the power of attorney for the individual taxpayers, and you have evidence in the record that the IRS said, "Okay, we know we want to get these extensions. Ernst & Young is going to help us out, especially if the partnerships are uncooperative." I don't view it as a material extension of TransPac. And our bottom line on what the practical consequence for the government would be is what they should have done here was asked. And that's what their own regulations say. If you have reason to know that somebody representing the taxpayer before the commission has a conflict, you need to ask, did you disclose and did you get a waiver? That's what Circular 230, which is in the CFR, it's their regulation, says, and it's what didn't happen here.
I know that this is not something that would feed back necessarily into the legal conclusion that you're urging upon us, but just as a matter of what happened, even after everybody knew what was going on, there was still an agreement to further extensions.
Yes, I get two responses to that. But first, we have a somewhat unusual statute extension language here that says if you're going to extend, you have to do it before the expiration of the period. I think that's at A5 to A6 of our blue brief. And so once the statute is expired, I don't think the subsequent extensions are legally relevant just to that analysis. But I take the broader point to be, is there something unfair about allowing the proposition or advancing? And I guess I would say two things. I mean, one, the calculus about what a taxpayer might do changed over time. We started with the discussion of Olson and the reasons at this early point, it might have been the right point to sort of make the choice. Once you've chosen a fork, the IRS investigation or the criminal investigation is further along and the calculus might be different. And second, I mean, the undisputed testimony from Calcove and Pettit is that they didn't know until much later, and that they didn't ask, at least at the key time for the extensions that were challenging, they weren't asking, their outside counsel. In some instances, the outside counsel didn't exist yet, and then the later extension, that just wasn't something they were asking their outside counsel about. My time has expired.
Judge Walker.
If I could ask one question on the extension, and then maybe a question or two about the second issue of whether this was a tax shelter or not. On the extension, can you give me it's a similar to a question I asked in the last argument. Can you give me a case where it wasn't the tax partner who had a conflict, but it was an advisor to the partnership that had a conflict with regard to either the tax partner or the other partner signing an extension, and the court ruled that the extension was invalid?
Right. So I may have to patch that together. The case that exists applying the propositions to statute extensions is the 22 strategic case. It comes out the other way, admittedly, but the claim there was that the individual taxpayer's accountant had a conflict. And I think the best part of that case for us is the notion that the court said, well, there wasn't a conflict for the advisor. There wasn't, I don't read the case as disputing that the general TransPac proposition would apply there. But in terms of doctrine, to get us all the way home, that's why we think you should read TransPac in light of these agency and fiduciary principles. And we cited the restatement, in part as a collection of actual law, but that's where you get essentially the third leg of the triangle. You've got, the advisor, and there, if you have, I don't take it to be disputed that if you have an agreement, and that's the word in the statute here, right? The agreement, that's what we're doing with these extensions, where a party knows or has reason to know that somebody is entering into that agreement because of a breach of fiduciary duty by an advisor, that is grounds to void or to avoid the contract. So I have to put those two things together. Admittedly, it's not a case from this court, but I think that's what we have.
I appreciate that. And then to shift to how the partnership and to the extent I know you don't say it was a tax shelter, but I want to try to figure out how it worked. I think I have a sense of how it worked, at least as much a sense as someone who has never run a tax shelter before might be able to figure this out. But I don't know, am I supposed to ask you this or Mr. Clark?
I'm happy to answer the question.
Okay.
I'll try.
Okay. So here's how I understand it. And if I wanted to put something like this in a fact section of an opinion, I want to see if you think it's right or not. One of these limited partnerships claimed a basis in BCP that was equal to, let's say, $700 million. That number, according to the IRS, was high because it took into account the long option while disregarding the corresponding short option. I know you would say it's not artificially high, but let's put that question aside. This limited partnership that has claimed a basis of $700 million has a capital account with BCP that is reflected with a $3 million figure. So basis of 700 million, but a capital account of 3 million. And that's because that 3 million is what the limited partnership paid for the options when the premiums were netted together. They took the long option premium, they subtracted the short option premiums they received, and it comes to $3 million. Then time passes and the limited partnership withdraws from BCP, and it receives about $500,000 worth of yen. And so it claims $700 million minus $500,000 in losses. Now, putting aside whether that was legal, perfectly legal, or a little sketchy, or completely illegal, that's not my question. My question is, do I basically have a sense of what happened?
I think that's right. I don't know that those are the exact numbers from the record. I took them to be hypothetical numbers, but that is the basic framework. If I could pivot to the one sentence legal point, which is that as I read ASA and VOCA, this court's decisions, the question is there a legitimate non-tax business purpose? And the thing that makes this case different from all the other cases that the commissioner cites is that we had undisputed expert testimony about the diversification benefit from this setup. And that's the part Your Honor's hypothetical didn't talk about, was what is it that was being contributed? And I think that's the hard thing if you're going to write an opinion against us. What is it that you say? Because for whatever reason, on the facts of this case, the government did not engage with the expert testimony that you in fact had diversification benefit by pooling, options from one partner that were in some currencies with options with other partners. And by doing that, you did what diversification usually does, which is reduce variability. So it's a little like putting some money in a bank account and not leaving it all in the stock of the company you just left.
So since you opened that door, let me ask. Here's my thinking on diversification here, and you tell me why you think I'm wrong. Diversification is obviously a business purpose if you are taking money in the bank and deciding how to invest it in a way that will make more money. So maybe I'll invest it in bonds and that'll make some money. Maybe I'll invest it in stocks, that'll make some money. Maybe I'll invest it in real estate. But you could always just keep it in the bank and neither make nor lose money. And your argument seems to be that this was diversification because they took some of the money that they could have kept in the bank and they put it in a place where they were guaranteed to lose money. And I don't see how that is consistent with diversification as a business purpose.
So I think my fundamental response to that is that diversification needs to be thought of distinct from profit motive. And I think the point Your Honor just made conflates the two. I mean, one way to think about it is preservation of capital is another business purpose. And the facts we had here were these were executives who were coming out of companies. Almost all of their net wealth was in the stock of that company. So they needed to diversify. And so it's not a question of having their funds in a bank and leaving them there. It's a question of what is the portfolio they can put together that in aggregate will avoid, perhaps will make money, but what will avoid potentially lost capital. And so, I take the point that there may have been other investments and that these may not be the investments that, Your Honor might make, but these were essentially bullish bets on currency. And the experts did agree that the taxpayers had essentially a 30% chance of doubling their money if the options expired in the money. And so it was a losing investment, but the question is, does that cross over the business, does that have no business purpose? And that I think, to return to what is hard for the court, if you're going to rule against us, is what do you say in the portion of the opinion where you say, we know we have undisputed expert testimony that there was in fact a diversification benefit achieved, and you have the language of BOCA and ASA, which says it's the absence of a non-tax business purposes that is fatal. So we're not talking about a facade. We're talking about a case where you have evidence of a substantial business purpose, and you need to balance the language of BOCA and ASA against the other proposition, which is the taxpayers are allowed to organize their affairs in light of tax benefits and sometimes to take advantage of tax benefits. So
you said that there's evidence there was a 30% chance of doubling their investment. I thought that there was something that was either undisputed or was a factual finding by the tax court that there was no way that the amount of money your clients could have made, there was no way that amount would be bigger than the amount of the fees that came along with the transactions.
Yeah, I'm sorry, I should correct. The 30% is if you have a particular option pair, what are the chances that that expires in the money, not the lottery payment, but just if the currency moves, and then you would double. The net premium paid was 16.5 for all the pairs, and you would then have 34. But you're correct that if you're thinking about it from a profit potential, you have to also take into account the fees paid, which, as I understand it, were 40 million on top of the 16.5 premium that you paid. So if I run that math and you take into account, the 30% chance of doubling your money, it is a losing proposition, as Your Honor stated. But the question is, you're still preserving some capital, and I think it gets to something like, you have a chance of preserving 60% of your capital. So again, that may not be what the optimal investment would have been.
Yeah.
It may not be.
And this is a friendly question, but I take it that when you're dealing with this much amount of money, you can't just safely put it in one bank account and leave it there and say, well, I know it won't make money or lose money, because I guess there's a risk the bank would go under, and there's not that much amount of money is not insured by FDIC, or I'm way over my head here, but is that kind of your point?
No, that was, yeah, I agree. And that's part of that's why I said the facts here are you have 4 corporate executives whose net wealth was completely concentrated in the stock of the company they had just finished running. They couldn't trade, while they were still there. And, that is very different than a bank account. If your company gets into trouble, as can occur, then your net wealth may go down. And I don't think the FDIC insures at the level of assets we're talking here. So that's why.
But there's other places you could go in terms of diversification. There's other places you could go that would allow for that kind of diversification without baking in a profit loss.
That's correct. And so, but I think the question is not, was this the optimal investment that, or even the question is not, was this, a rational investment? It is there a legitimate non-tax business purpose? And again, the thing about the record of this case that I don't think the tax court engaged with was the expert testimony unrebutted that there was in fact an objective diversification benefit because of the pooling. And that's a fact that's not present, as I read it, in any of the other cases cited by the commissioner.
Okay. Thank you, Mr. Marwell. Unless my colleagues have further questions.
No.
We'll hear from Mr. Clark, and we'll give you the rebuttal time you requested. Mr. Clark?
Good morning, and may it please the court. George Clark on behalf of the Esri and LeMay appellate entities. As Mr. Marwell indicated, I'm going to address Rule 63, but obviously also here to field any specific questions you have about Esri and LeMay. Rule 63 requires 2 things, basic things. 1, that the judge be sufficiently familiar with the record, and 2, that the judge determine that the case can be completed without prejudice. On that second point, the rule actually puts an affirmative duty on the judge to make that determination. And as the advisory committee specifically cautioned, courts risk error to determine the credibility of a witness that's never been seen or heard. And that's natural. That makes sense, right? I mean, the Supreme Court's instructed that courts always have to be sensitive to the problems of making credibility determinations. We understand that, right? You need to be able to see these witnesses speak. Echoing the advisory committee, this court in Thompson explained that a retrial could be warranted even with the party's consent if the credibility of witnesses is in question. So let's talk about these credibility determinations, right, that Judge Holmes made. As Mr. Marwell and you have been discussing, a key question in the case is whether E&Y misled the taxpayers regarding its criminal investigation when the statute extensions were signed by Charles Bolton. That's kind of core to the case on the timeliness point. Now, for their part, the taxpayers testified that E&Y never told them about the investigation, and certainly never told them that E&Y had a desire to cooperate or intended to cooperate, right, with the government. But without hearing from the taxpayers, Judge Holmes, and the cites I'm going to give you are from the Joint Appendix at 2408, which is the opinion at 44, Judge Holmes found that he could not believe that E&Y hid its intent from the taxpayers, as they claim. He also found that as to Mr. Esther and Mr. LeMay, that they understood, quote, far more than they let on, and that this, quote, undercut their claim that they had blindly relied on E&Y. Again, this is all without ever hearing them speak. Finding witnesses lacking credibility on such critical points without even seeing them speak isn't even due process, much less consistent with Rule 63. Now, in fairness, Judge Holmes pointed to King and Spalding. That was outside counsel. Mr. Marwell referred to some of these people had outside counsel. So he referred to King and Spalding's involvement as a contemporaneous advisor as one of the reasons why he didn't believe that they relied solely on E&Y. But both Mr. Esri and Mr. LeMay testified in detail as to why King and Spalding was hired, what their relationship was, how they talked to King and Spalding, what they relied on King and Spalding up for, what they didn't. And remember this, King and Spalding didn't know about this criminal investigation, right? They couldn't have. E&Y didn't tell them. No, and E&Y didn't tell the clients. Similarly, Judge Holmes relies on this mid-2003 call from the New York Times, right, to Mr. LeMay. He says that's something that should have got Mr. LeMay, as a sophisticated businessman, should have got his antenna up. But nowhere in the opinion does it address that in the witness stand, Mr. LeMay specifically talked about what he did after he got that call. that he picked up the phone and called Bob Copeland at E&Y and said, Bob, what is going on with this? And Bob Copeland told him, look, this has nothing to do with you. It has nothing to do with this case. It has to do with, these E&Y record keeping and filing compliance issues.
Mr. Clark, let me give you a chance to correct where I am on this. I understand your argument to be that very sophisticated businessmen, your clients, had read in the newspaper, had been told by a newspaper reporter, and had been told by King and Spalding that Ernst & Young might be up to no good. And the reason, according to you, why it was justifiable for them to continue to rely on Ernst & Young is because they called Ernst & Young and said, is everything on the up and up? And Ernst & Young said yes. I don't know that would be justifiable reliance with the most unsophisticated party, but we're talking about corporate tycoons here. Tell me why I shouldn't go down that road.
First, Your Honor, I would say that the sophistication of the executives notwithstanding, they had been in relationships with E&Y since the 80s, right? They trusted E&Y with everything in their financial lives, okay? So there's an evolution.
I'm sorry, Mr. Clark, hadn't they already been asked to resign by Sprint because they had previously taken the advice of Ernst & Young?
It depends on which points of time you're talking about, Your Honor. You'd have to look at the timeline. There are points in time when some of this happened that was after that point.
The first time they signed the extension was December 4th, 2003. That was Esme. And then, so let's take that. By December 4th, 2003, hadn't they already been asked, maybe I'm wrong on my timeline, had they been asked to resign by Sprint by December 4th, 2003, because they had followed, in part because they had made some decisions based on bad advice from Ernst & Young?
Your Honor, I believe that is correct.
But your argument is that it was still justifiable for them, even having lost their jobs, to continue to rely on the people whose advice had cost them their jobs?
Your Honor, what I'm saying is E&Y was telling them that there was nothing to worry about, that they were okay, and that this would work out okay. And what matters in our context is no one that has decided this opinion has sat and listened to them and seen their faces and had them explain this, not me, about what they were thinking. Okay.
But you consented to that, and they consented to that, right?
Your Honor.
Go ahead.
Sorry, we consented to a decision without recall of witnesses. We didn't agree to a decision that made factual findings that were contradicted by unrebutted testimony. Okay, when I say unrebutted, but Your Honor, when I say unrebutted, right, we're not talking about.
Let's say I consented to arbitration, but I didn't like how the arbitrator found facts.
No, I don't think it.
Speaking of that, I mean, this is also on my mind, so I'll give you a chance to tell me why it shouldn't be. Sprint, for example, while your clients were running it, had contracts of adhesion all the time. And I'm sure Sprint was arguing in court every day of the week that, for example, the arbitration clauses in those contracts of adhesion should be enforced. And I'm sure that their opposing parties were saying, we didn't really know what we were getting into. And your clients would say, no, a deal is a deal. A contract is a contract. An agreement is an agreement. And for them to then come here and say, yes, we signed the extensions and we made an agreement, but we were misled by a third-party advisor.
Your Honor, this isn't a little thing. This is a big thing. Your third-party advisor under criminal investigation after Arthur Anderson has actually imploded because of a criminal investigation. E&Y, it was all hands on deck to try to save that entity. I mean, they hired Williams and Conley, the most sophisticated criminal tax counsel in D.C., right? They were seriously concerned about this. But let me go back to the point about, this unrebutted point. We're not talking about a situation where we have one witness that my witness said the light was green and the other witness said the light was red. Okay. In that, you can blame us for not asking for, for not asking for a retrial. Okay. No witnesses testified to the contrary in all these statements that I was talking about. No witnesses testified to the contrary. There's no contrary documents. When IRS counsel cross-examined these men, they drew the same testimony. It's all one way. And as Judge Holmes was putting his opinion together, if he's thinking to himself, look, I don't believe these people. I just don't believe them. He needs to ask for a recall himself so that he can see what they say. I thought they were credible. I can't vouch for my own clients. I can't vouch for witnesses, but that somebody needs to hear them say this as a matter of due process and under Rule 63.
My only last thing, Mr. Clark, is with regard to Williams and Connolly. I'd always heard everyone say that Baker and McKenzie were the best tax lawyers in D.C. I'll take your word for it on Williams and Connolly.
Thank you, Your Honor.
Unless my colleagues have anything further for you, Mr. Clark, we'll hear from the government. Thank you. Mr. Rubin?
Good morning. May it please the court. My name is Jennifer Rubin, and I represent the commissioner in this case. This case arises from a marketed tax shelter in which taxpayers used short-term, self-contained, guaranteed money-losing transactions to generate artificial tax losses far in excess of the money that they paid to participate in it. The tax court properly upheld timeliness and the substance of the commissioner's administrative adjustments. I'd like to start with timeliness. And, you know, as I was reading through the reply brief, it really struck me that the taxpayers here are seeking to expand the Transpac line of cases in 4 critical ways. And I'd like to go through each of the 4 and then go back through them in more detail. Number 1, they're seeking to expand to advisors and not just to the signatories on the extension consents. Number 2, they're seeking to broaden conflict to include any time that a third party has an incentive to favor their own interest without requiring any IRS knowledge that these taxpayers in particular likely have different views on extending the time. Number 3, they're trying to rely on institutional knowledge without any showing that the people who obtained the extensions, the people in exams, had any reason to know of any alleged conflict. And number 4, they've tried to expand the understanding of what is a criminal investigation. Let's go through each of those in back in order. Back to number 1.
Can you repeat number 2? Sorry, I just wanted to make sure I get that before you go back to number 1.
Sure, and if you'd like, I could start by talking with that one. It's broadening the concept of conflict of interest to include any time a third party has an incentive to favor their own interests and not requiring IRS knowledge that the taxpayers likely have a contrary view on extending the time. And I'm going to hook here directly to the Henry Martinez case out of the Fifth Circuit. At 564 F. 3rd at 729, it says it requires a showing that the tax matters partner had cause to prefer his own interests and that the IRS knows that the quote, actions are more than likely contrary to the wishes and interests of the limited partners. All 3 invalidating cases here actually include those specific facts, both that the IRS knew that there were incentives to favor their own interests and that the tax matter partner's interests actually conflicted with the actual or likely interests of the partners. Transpac, the IRS knew that the tax matters partners were aware that they were targets of an active criminal investigation, and they knew that the limited partners had refused to sign extensions. Leatherstocking, the IRS knew that the tax matter partner had a secret plea agreement with the government promising to help resolve the tax claims of the taxpayers, and also knew that the tax matters partner was defrauding the limited partners who therefore had an interest in expediting the investigation in order to establish, to learn about the fraud and to stop the fraud. Number 3, River City Ranches. The IRS knew that the tax matters partner was defrauding the limited partners and knew that the IRS had already lost the first case in that particular tax shelter and needed additional time to investigate the tax shelters, which was how they uncovered the fraud, such that the limited partners had specific reasons to expedite litigating their case. You know, and what's really interesting is, you know, the taxpayers in their reply brief go into, oh, here's this tax court remand from River City Ranches where they threw out this extension. But what's really interesting there is that they didn't throw out all the extensions in the case. They only threw out the extensions after the IRS learned of those contrary interests, after they learned about the fraud.
So can I ask you, is your broader point here, I get that there's some detailed factual points about these cases that may or may not be salient distinctions, but is your broader point here that look, there's only so much that the IRS can be expected to investigate and look into before it relies on these extensions, because it needs to be able to rely on extensions because that sets the kind of administrative architecture so that the IRS can go on and do its work. And you'd have to dig really, really deeply to figure out what was underlying some of this. Whereas in some of the cases that you were just talking about, it was obvious. The IRS already knew. Is that the point, or is it that actually the underlying incentive structures were different in those cases as opposed to this one, in that in those cases there was actually a reason to want to deny the extensions, whereas here there's not a reason to want to deny the extensions? Because as to the latter one, there is testimony in the record that there was a reason that the taxpayers might want to deny the extensions. There was a tactical reason that they might want to deny the extensions.
I'd say it's both points. Obviously, as we argue in our brief, we need to be able to rely on extensions. And but I would say that the fact that there's specific knowledge of reasons specific to these taxpayers in Transpac, Leatherstocking, River City ranches, why they in particular might not want to extend, is actually quite relevant, because they don't have anything of that here. They have somebody who comes back after the fact as an expert. I don't think actually admitted to talk about this point, but in all events comes in and says, well, theoretically, hypothetically, it might have been to their benefit to not extend, maybe, but there's no indication that the IRS was aware that they more than likely would not have wanted to extend. In fact, the IRS was aware of one very big reason why they would want to extend. And that is the potential to participate in a global settlement initiative, which in fact, for the CDS shelters, the IRS did provide a global settlement offer in 2006, which only taxpayers who had extended their time were going to be eligible to try to get a hold of. And notably, most taxpayers did, in fact, seems like they settled their cases for CDS. Very few actually tried to litigate their CDS shelters. And so from the IRS's perspective, and there's absolutely nothing contrary to this to show that the IRS had specific knowledge that these taxpayers had more interest in expediting than in extending. They would look at it and say, I think they have an interest in continuing to go forward and have the period be extended so that they could potentially be offered of the global settlement. And so I would say it's really both of the points that she made, because clearly, especially when you consider, going back to my first point, that they're trying to extend Transpac beyond just the tax matters partner who actually signed the extension to the advisor. It really does mean that we would have to do an investigation of each and every extension, particularly in partnership cases. And
so can I ask you this question, though, just at a high level generality? So if you have a situation in which, let's suppose there's no gap between Bolton and E&Y. Let's just take that out of the field division. I know you don't want to do that, and I think that might have been your first of 4 points. I can't remember, but let's just suppose that we just collapse it and we only have one conjoined entity that's an issue. So we'll remove that gap, and then we also say that the IRS knows that joint entity has a conflict of interest, but the IRS doesn't know that the taxpayers would have a reason to deny an extension.
Right.
But are you saying that even in that situation, we should take the extensions at face value?
Yes, because you need to, for there to really be a conflict of interest under these cases, and again, I'm going to point you to Martinez, you need to show both that the person who signed, let's just say hypothetically that Bolton was the one that there was an investigation of. So we'll just ignore Ernst & Young for the moment. Okay. You'd have to know that Bolton had an incentive to favor his own interests, but you'd also need to know that his interests actually conflicted, more than likely conflicted, with the interests of the taxpayers. Otherwise, if you have an interest to favor your own interests, but they happen to align with the taxpayers, no harm, no foul. And that's what the case law says. And there's been absolutely no cases that have thrown out any extension consents where there hasn't been a showing that the IRS was aware of specific facts establishing that the taxpayers either objected to extending the time, as in Transpac, or likely would have objected, as in leather stocking and River City ranches. There's simply no case that supports that, and for good reason. You need to be able, the tax system relies on extensions. Extensions are very frequently given out. It's a kind of standard, I believe both Phillips and Madison Recycling made the point, this is kind of plain vanilla. This is something that happens all the time. And so for the IRS to look behind it, they really need to have some reason to think that these taxpayers had reason not to sign, and not just some hypothetical that someone came up with years after the case, but actually had facts at the time saying these taxpayers had reason not to extend. And therefore I have reason to distrust the extension that I'm going to rely on. There's several $100 million of taxes at issue here. The IRS relied on these extensions.
So it's not enough that there's just a conflict. I mean, when we talk about a conflict of interest, we're assuming that there's a conflict of interest as between, the way you helpfully refashioned the hypo of Bolton and the taxpayers. We're assuming that there's a conflict of interest, but what you're saying is even the existence of a conflict of interest as between those two doesn't matter unless the IRS has reason to think that as to the particular issue of granting an extension, there would be a reason that Bolton would want to acquiesce in an extension, but the taxpayers might not.
Exactly. And
but you don't need to. I don't think you need to win that in order to get an affirmance here. I understand that may be your theory.
No, I think they lose if they will lose on any one of these points.
Yeah.
This is a tremendous expansion they're looking for. And every single one of these points I think is very problematic, but we don't have to win all four. Absolutely not. They're all independent. Turning to number 3, they're relying on an institutional knowledge of a conflict, and they're not requiring any showing that the employees in examinations knew the alleged conflict. And again, in each of the cases, as best as I can read them, Transpac, Leatherstocking, River City Ranches, the people handling the exams, the ones who actually obtained and relied upon the administrative adjustments, they actually had knowledge of the facts that were relevant, which is not true here. Now, it is true, as my opposing counsel noted, there is some language in Phillips regarding attributing knowledge of examinations and the criminal investigation division to the commissioner, but there's nothing saying that you should go in reverse. And then the fourth and final thing is that they've really expanded an understanding of what it is for there to be an active criminal investigation for anybody to be aware of. As my opposing counsel described it, you have this phone call that comes from somebody at the Southern District of New York who says, "Hey, I saw an article. I think you should be preserving documents and let me know if there's anything illegal has gone on." The following month, in July 2002, the chief counsel of the IRS talks to counsel for Ernst & Young and says, "We have not made any criminal referral for Ernst & Young." Also, that same person from the Southern District of New York also talks to Ernst & Young's counsel and says, they have not made any criminal referral at this time, which they hinge a lot on that "at this time" language. But I'm still concerned. And based on that, they say, well, there you go. There's your incentive to go against our interest, which again, no showing that it is against their interest, but it also is very problematic that they have expanded it to this extent, that if somebody somewhere in the Department of Justice makes a phone call, that there you go, suddenly we should be assuming that Ernst & Young is acting outside of the interests of the taxpayers. And again, I know for hypothetical sake, we assumed that Bolton had a conflict, but again, there's absolutely no evidence of that in the record, and certainly no evidence that the IRS would have been aware that he had any conflict. And that being fact, if you focus solely on the tax matters partner, which we believe he should under the case law, they lose. And one final point, they did make a point, my opposing counsel made a point regarding timeliness, saying, well, you have to have the extension has to be done before the time has run out. And so you should ignore all the subsequent ones. We don't think that's true because I think it does go to whether, in fact, they actually had any conflict of interest here. But in all events, that really raises the point that since they've conceded everything, all the extensions that were done after September 2004, they basically conceded timeliness for tax year 2001 because all of the extensions that happened for tax year 2001 were in later timeframes after Ernst & Young was no longer involved. So really, timeliness only goes to tax year 2000. If I could briefly turn to the sham partnership thing, I just wanted to reiterate that to the extent that there was any diversification benefit, it was solely within the context of this short-term, self-contained, money-losing tax shelter. And it only really operated in tandem with doing two things that were critical to operation of the tax shelter. Number one, consolidating in one partnership so you could get that basis increase. And number two, ensuring that you got some distribution of yen. It basically kind of reduced the chances that any one of these partnerships would have $0 distributed to them from the partnership. Are there any further questions on sham partnership or on Rule 3?
On sham partnership, Ms. Rubin, what's the difference between an illegal tax arrangement and the things that people do all the time where they, instead of putting money that you want your kids to inherit, you in a bank account, you put it in a trust, or you want. My understanding is that people make decisions all the time that have no purpose other than to avoid paying taxes, and that those are legal. And then I also am completely on board with the case law from our circuit and elsewhere that there is a line that someone can cross and it becomes illegal. How is this different than a parent putting money in a trust so the kid inherits money that's, more tax-free than it would otherwise be?
Well, the trust situation is one where somebody's actually taken a material step to remove themselves from having control of that money and put it into some other entity. And there's the laws of trust are pretty complex, but
or maybe just like they put their money in a 401k instead of a regular stock market account, and they do it because it has tax benefits.
Right. That's because that's what the law intended, and what the economic sham doctrine basically is really all about is saying, Congress can't think of every single thing, and so we're going to look behind this transaction and say, was there a legitimate business purpose, or was this simply for tax avoidance and not for what Congress intended? Congress, say, for instance, with your 401k example, Congress decided to give an incentive to people to put money aside for their retirement and said, okay, we're going to let you do this up to this certain amount, and you're going to get some tax benefits from that because we want you to do that. And
Ms. Rubin, let's imagine that I'm a tax lawyer and a client comes in and says, I have $100 million and I want to pay as little taxes as possible. That's my only goal. Give me your advice. Am I allowed to answer that question?
Yes, you're allowed to answer that question, but you're not allowed to pick a tax shelter that is basically just economic waste done in order to create artificial tax losses. That's a lot of the problem here, is that there were artificial tax losses.
That's my question is what's the difference between artificial tax losses and tax losses?
Okay, so for example, they paid $16.5 million net to purchase these option pairs, but they claimed $3.1 billion of losses from them. And that since they didn't economically experience those losses, they weren't really the types of losses that Congress intended you to deduct. That's an artificial tax loss. It's money that you claim you lost, you didn't lose. And here what you have is these taxpayers, Calcoven and Pettit saw that they were going to have a whole lot of money coming in. So they engaged in a whole bunch of tax shelters. They engaged in Cobra Shelter, they engaged in CDS, and then they engaged in add-on. And add-on in particular it created these absolutely artificial tax losses and had zero chance of being profitable, which is at this point really, it's uncontested. That being the case, you look at it and you say, is this really what Congress intended, was for someone to engage in something that has zero chance of profiting in order to claim losses they didn't experience on their tax returns. And that's really where, ASA Investorings and the Culbertson line of cases that ASA actually relied upon, and Boca Investorings, which cited both ASA and Culbertson, and in tech, which cited both ASA and Culbertson. That's what these cases are really saying, is that when you really have this transaction that's actually just a wasteful way of claiming false artificial tax losses without any real business benefit. We stand by on our brief as to why, in fact, the diversification argument really was just a facade, because again, it was just within the context of this tax shelter that was designed to create artificial tax losses.
Can I ask just one last, unless my colleagues have further questions, I just want one last question, which I think is in the same vein as Judge Walker's question. There's some sense that this tax, I'm not trying to use scheme pejoratively, but I can't think of off the top of my head of another word for this, but the tax enterprise at issue here is a cousin of son of boss.
Yes.
And can you just describe, at whatever level of generality you choose, and as efficiently as possible, why this is a cousin of son of boss, since we already know that son of boss is a tax mechanism that fits in the category of unlawful ones?
So basically, you had this transfer to a central partnership of a pair of assets, one of which was, in theory, worth a lot of money, and the other one, which was absolutely attached, had a contingent liability. And then by putting in the partnership, they claimed the basis for that high value item and ignored the contingent liability, even though when they actually bought these two items, they paid a net premium that was substantially lower. Then when they inevitably lost money, they came back and said, oh my gosh, I lost all of this basis that I had in this partnership in BCP. And it really all comes down to that same stream. I believe the tax court has a nice little paragraph that we quoted in full in our brief that just kind of goes through why this is a cousin. But that's really what it comes down to, is the pairing of the asset and the contingent liability while ignoring the contingent liability for purposes of your basis claim.
Okay. Thank you, Mr. Rubin.
Thank you.
Mr. Marwell, we'll give you, I believe you requested 2 minutes. We'll give you your 2 minutes of rebuttal.
Thank you, Your Honor. If I could talk first about whether we are asking for a material expansion of TransPac. One observation, a decent portion of the commissioner's argument relied on issues that the tax court did not make findings on, such as the IRS's knowledge or lack of knowledge. And that puts this court in an awkward position. If the court concludes that those are the key issues, then a remand may well be appropriate. 2 reasons why we're not asking for a substantial extension. First, the basic conflict here that the extension was being granted at the urging or direction of somebody who was under criminal investigation is the same as in TransPac. And the Second Circuit found it essentially self-evident that somebody signing, that there would be a divergence between the interest of the person who's under investigation and the limited partners. As to the question of whether the IRS had specific reason to know that the signatories here might have had a different interest than the taxpayers, TransPac cited the Internal Revenue Manual for this proposition. The IRS would at least be on notice of that and that fundamental conflict. On the institutional knowledge and the question of which agency employees, I take the commissioner to be asking this court to do something different than the Ninth Circuit. And you do have even if you disagree with the Ninth Circuit, you have things like the IRS's non-docketed service advice quoted in our brief that says, even the target of a civil promoter audit can have a conflict for largely the same reasons as the criminal, as the target of a criminal investigation. And as to whether there was an active criminal investigation or not, I mean, the key is whether the Ernst & Young or the signatory was under intense pressure because of the existence of a criminal investigation. And the Southern District called Ernst & Young a week after Arthur Anderson was convicted and essentially imploded because of these kinds of things. And so I think whether or not you think it's one investigation or it was interrupted, the pressure existed, in our view, until 2013. I see my rebuttal time. Could I make one point on the sham partnership? And then, thank you. The key problem for the commissioner, I think, is the record here at trial and the undisputed expert testimony about the diversification benefit. There's all sorts of things that taxpayers do with an eye towards tax benefits. Think about purchasing municipal bonds, an investment you might not make but for the tax benefit. The court should hold the line on VOCA and ASA and stick with the view that if you have a legitimate non-tax business purpose, that is enough to avoid this very harsh medicine of shamming a partnership. If there are no further questions.
Thank you, counsel. Thank you to all counsel. We'll take this case under submission.
This honorable court is now adjourned until Thursday, November 19th at 9:30 a.m.